Welcome to today's program, Defending the Boss, preparing CEOs, directors, and other senior executives to testify in depositions. My name is Zach McGee. I'm a Senior Vice President, Business Affairs for Sony Pictures Entertainment. Prior to joining Sony Pictures, I was an in-house lawyer at NBC Universal, and before that, I was a lawyer at Davis Polk. I've been writing and speaking on legal education topics for the past 20 years, including having taught a course on legal ethics at Pepperdine Law School. As you might expect, I'm speaking today solely on behalf of myself, and my views don't reflect those of my current or any former employers or institutions with which I've been affiliated. I bring a unique perspective to today's program that I am excited to share with you. Let me explain what I mean. When I first started my legal practice some 25 years ago now, I was a litigator at Davis Polk, where I took and defended scores of depositions. I mostly represented large corporate clients that were defendants in securities or M&A cases. And those are the types of cases that often involved dozens of depositions, because the parties had virtually unlimited resources with which to litigate or defend against the claims at issue. While at Davis Polk, I worked on many high-profile cases, including Oracle's hostile takeover of a rival software company known as PeopleSoft, in which Oracle's founder and then CEO, Larry Ellison, played a key role that I will discuss in more detail later. I was one of the lawyers at Davis Polk who helped prepare Larry to testify, both on deposition and at the trial in Delaware Chancery Court in support of Oracle's successful acquisition of PeopleSoft. Some of my other large corporate clients included JP Chase, Bank of America, and Deutsche Bank. In that capacity, I represented MDs, SVPs, and other senior executives at these banks, as well as CEOs, CFOs, and members of the boards of directors of other large companies, including Cisco, Keebler, Robert Mondavi Winery, and Yahoo. So, at the start, I bring your typical large law firm litigator experience to the topic of preparing senior executives to testify on deposition. After Davis Polk, I moved in-house, where I worked as an in-house litigator with NBC Universal here in Los Angeles. In that role, I continued to prepare senior executives to testify, but as an in-house lawyer, I was working alongside outside counsel. So I had the opportunity to see how litigators at other large law firms, such as Munger, O'Melveny, Gibson Dunn, Latham, and others, prepped witnesses they represented. I don't think these other lawyers did it any better than we did it at Davis Polk, but I definitely picked up a few pearls of wisdom from seeing how other experienced litigators handled the same types of situations that I had encountered when I was outside counsel. The other major difference when you are in-house is that you are now helping to prepare witnesses who are not just your clients, but are your coworkers, colleagues, and sometimes also your friends because you work for the same company. As an in-house lawyer, I was privy to much more of the witnesses' thinking and concerns about the matters at issue in the litigation and that were likely to come up in the deposition than I ever had been when I was outside counsel, which is also helpful when preparing them to testify on deposition. That is also when I discovered that even if you represent the same company and many of the same people at that company over and over as an outside lawyer, as I routinely did for companies like JP Chase and Deutsche Bank when I was at Davis Polk, you are still outside counsel, and consequently, you still are not going to be let fully inside the tent. Even in-house lawyers don't always get let fully inside the tent by their business clients, but I can tell you from personal experience that they get included much more than outside counsel do. So, I also bring the perspective of an in-house litigator who helped prepare his colleagues to testify, and in one special case, the woman I later married, who I met when I was preparing her for her deposition. So that's further proof that I know what I'm talking about and pretty good at it when it comes to deposition preparation, because if her deposition hadn't gone so well, I highly doubt my wife would have chosen to marry me, but I guess we'll never know. Finally, and this is the part that is most unique, while I didn't write the book on deposition preparation, I actually wrote the script. Based on my many years of law firm and in-house experience preparing witnesses, I wrote and produced a deposition preparation video called Deposition Testimony: 5 Simple Rules. That program is distributed by a company called New Media Legal Publishing, which I co-founded and where I am currently serving as the chairman of the board. To say that the Deposition Testimony: 5 Simple Rules program has been highly successful would be an understatement. Thousands of witnesses have used it to help them get ready for their depositions. National law firms Baker Botts, Ballard Spahr, Gibson Dunn, Mintz, Morrison & Forster, O'Melveny, Orrick, and Shepard Mullen, among others, use the Deposition Testimony: 5 Simple Rules program with their clients and have been doing so for many years. We even have a Canadian version for use by lawyers in Canada to help prepare witnesses to testify in discoveries and out-of-court cross-examinations. As you might expect, I am a huge believer in the value of using a deposition preparation video to help you prepare your clients to testify on deposition. It is equally useful for low-level employees as it is for the most senior executives for reasons that I will explain as we make our way through today's program. To quote a Russian proverb, it is better to see once than to hear 100 times. In a nutshell, once you've used the Deposition Testimony: 5 Simple Rules program with a client, you'll be amazed at how much better the client performs in his or her deposition. The program brings to life all the fundamentals you will cover with them and drives them home. In particular, your clients will see witnesses testifying the right way and the wrong way, and they will experience what their depositions will look, sound, and feel like. Perhaps as importantly, particularly for senior executives who often are not inclined to take their depositions as seriously as they should, they will see the harsh consequences of getting it wrong. At the risk of sounding overly salesy, you don't need to take my word for any of this, nor should you, since I just told you that I wrote the script and am the chairman of the company that distributes the program, because you'll have the opportunity to see for yourself as we will provide you with a preview of the first 4 chapters of the Deposition Testimony: 5 Simple Rules program later in today's CLE presentation. With that admittedly lengthy introduction, here is our agenda for today, where we will be tackling the often daunting task of preparing CEOs, directors, and other senior executives to testify on deposition. First, we're going to talk about lawyer preparation. We've all heard the advice that every battle is won before it's ever fought. If not from reading Sun Tzu's The Art of War, then you might remember the scene from that classic film Wall Street, where Michael Douglas's Gordon Gekko repeats this famous line to his protege Bud Fox. When we are talking about depositions, both taking them and defending them, preparation is critical, and in the latter case, it's preparation not only of the witness, but of the lawyer as well. That means that you, as the lawyer, must be fully prepared before you sit down to meet with your client for the first time to discuss the case, and certainly well before the client goes into the deposition. I've broken down the overall requirement of lawyer preparation into 3 buckets. 1, mastering the law, 2, mastering the facts, and 3, identifying key players. We'll spend a little time today talking about each of those things in some detail. Then, we'll turn our attention to witness preparation, and this is where you're going to be working with your witness to get him or her ready to testify on deposition. I've broken this down into 4 different buckets. 1, preliminaries, 2, substance, 3, procedure, and 4, practice. We'll introduce the concept of using a deposition preparation video to help prepare your witnesses to testify in the procedure phase of our discussion. Before we kick things off, I want to spend a minute talking about who I believe can benefit from this program. Certainly, it's going to be very useful for newer litigators who haven't had a lot of experience with depositions. Maybe this is your first time preparing a witness to testify, or maybe it's your second or your third time doing that. And you certainly will learn some things today that I believe will make you better at the task of preparing your clients to testify. So, newer litigators will benefit a lot. But we're also going to be talking about some advanced concepts. In particular, some of the rules that apply when you're prepping senior executives. And this should benefit more experienced litigators, who often are tasked with preparing more senior executives, either on your own or working in tandem with your more senior litigators at your law firm or company. Taken together, Everything that we're going to cover today is going to apply to defending any deposition in any civil case, but we're also going to focus at various times on senior executives and some of the challenges that they present when you find yourself representing a CEO or a director or another very senior person at a company. While there are some benefits of having a more senior and typically more sophisticated witness as your client, these witnesses also present some unique challenges, and that's what we're going to cover today. Let's move to our first topic, which is mastering the law. I'm not going to say too much about this today, other than to note that it's very important. Preparation in general is critical in terms of defending a case, or if you are the plaintiff in a case, it's crucial that the substantive area of law that forms the basis for your claims is something you know very well. As the plaintiff, you must know what you need to prove in order to prevail on your claims. And if you're the defendant, you likewise need to know what the plaintiff needs to prove so you can defend those claims. And in cases where you have counterclaims or cross-claims, what the elements of those counterclaims or cross-claims are in order for you to be able to prove them up at trial or on a motion for summary judgment. As a defendant, you also might have affirmative defenses that you likewise need to establish, so mastering the substantive law that applies to all aspects of your case is key. Indeed, if you think about it, the underlying substantive law establishes the baseline for everything in the case, including what discovery is permitted, and that of course includes depositions. Discovery is about uncovering facts that are relevant to some claim, some elements of a claim, some defense, etc., all of which are established by the underlying substantive law. Unless the elements of the claims, defenses, counterclaims, and anything else that is an issue in your case, unless you know these, you're not going to do a very good job preparing your clients to testify on deposition, because you're not going to know what's relevant and what isn't relevant. As I'm sure you know, defending a deposition is playing defense in a lawsuit. You are not trying to affirmatively score points or to get out on the record facts that will prove your claims or disprove the other party's claims. Your witnesses can testify to what you need to establish directly in court or via affidavits when it is necessary to prove the elements you need to prove. Your goal in defending a deposition is to play defense, to prevent the other party from obtaining any information beyond the bare minimum that is necessary to respond to the questions that party's lawyer is asking your witness in the deposition. We'll cover this in more detail later, but you'll be counseling your witness not to volunteer, not to speculate, and to answer only the question he or she is asked. To use a football analogy, you're playing a game of defense where you are solely focused on preventing the other team from scoring field goals or, God forbid, touchdowns, and not on putting your offense on the field in an attempt to score points yourself. Now, there are exceptions to this, areas where you'll want your witness to be ready to testify to more than the bare minimum, such as when he or she is asked what the witness did to look for responsive documents in the case, or perhaps there is some other narrow point that needs to be made. But those are the exceptions and not the rule, which is simply put, don't volunteer. To bring this back to the substantive law, when you have mastered the substantive law, you will know what evidence the plaintiff needs to prove its claims, and so you also will know that part of your job in preparing your witness is to deny the plaintiff that information, if at all possible. Of course, your witness always must tell the truth and must answer the other party's questions, but within those rules, your goal is to limit the amount of information the other party's lawyer obtains in the deposition, and ideally, to minimize the amount of information he or she obtains that could be used to establish necessary elements of that party's claims. In terms of knowing cold what the other party needs to prove in order to prevail in the case, it's a very good idea to read the jury instructions that apply to the claims and defenses in your case. It's never too early to start thinking about the end game, and even though very few civil cases go to trial, that doesn't mean that you shouldn't pay attention to what the jury instructions would say, because again, that's how the issue ultimately would be framed for the jury, and discovery is the method by which evidence to present to a future jury or to a judge is obtained, or not obtained. For the same reasons, you need to be aware of the summary judgment standard and any burden shifting that may occur, as well as any procedural law that may be applicable, such as in cases where personal or subject matter jurisdiction is in dispute. Many more cases are won or lost on summary judgment than at trial, so it's just as important for you to understand how your case will be positioned at that critical stage of the lawsuit. Every case is different, and so my point is that it's critical to understand how the procedural law works in terms of what a prima facie case is, what you can use to rebut that case, what you can use to rebut the rebuttal, etc., as that will impact what information can or should be obtained in discovery. Mastering the law means that you need to understand completely the substantive and procedural law that governs your case before you can think about how best to prepare your witnesses. The next major topic under mastering the law is having your theory of the case. Of course, your theory of the case is something that you've been developing from the moment you got the call from the client saying, hey, we've had this issue, or we have this lawsuit that we need your help with. So that already will be a work in progress by the time depositions are noticed. Indeed, one of your main tasks as a litigator is to develop a theory of the case that fits the facts and that ultimately supports your client's position, whether you're trying to prove your causes of action or you're the defendant who's trying to rebut them. You need to have a theory of the case that fits with the facts, that ties everything together, and that leads the judge or jury to the result you are trying to obtain for your client. The key thing you should be aware of is that your theory of the case will change, often many times, throughout the course of the litigation. You certainly are going to have some theory when you start, and then as you learn more both from your own witnesses and documents, and potentially from depositions and documents from the other side, be prepared for that theory to be modified. Sometimes you even need to discard your theory entirely and replace it with a completely new theory if the facts lead you in a different direction, or in rarer cases where the substantive law changes. Whatever happens, you need to have a theory that ties together all of the evidence, and it's something that you constantly will be revising as you go along. So that's my advice with regard to mastering the law and why it's a critical first step to preparing your witnesses to testify on deposition. Let's turn now to mastering the facts. The first thing here is to review and digest all of your documents. That's the documents that you produce from your client's files, as well as any documents that were produced to you in discovery. If you're a more junior lawyer, you're likely already very familiar with this part of the process because generally that's where junior litigation associates cut their teeth, reviewing and analyzing documents produced in discovery and writing memos summarizing the key points of documents that you've collected and produced or that have been produced and collected for you. What's critical about the document review process is being able to answer a simple question. What do your documents actually prove or suggest to be true? In my experience, you often get a very different picture of a case as a result of the documents that are produced versus what people tell you in your interviews. There are many reasons why this is so often the case. One is that there may be different people at the company now than were there during the time period that is an issue in your case. It's very common for discovery in a lawsuit to be taking place many years, and in some cases decades, after the time period that is an issue. So there may not be any people at the company now who were there then. Documents, on the other hand, have an infinite memory because they fix information at a point in time, whereas people come and go. And even if the same people are at the company when you interview them, people don't have perfect memories, particularly for events that may have happened many years ago. We'll talk later about using documents to refresh the recollection of your witnesses. It's not always clear that you want to do that, and even if you do, there are some things you need to think about first before you choose what documents to use for that purpose. But suffice it to say that people often misremember events that occurred in the past, sometimes even events that happened only a few months ago. Your client's employees, particularly senior executives, are very busy and often their recollection of events, even very important events, gets pushed out of their heads to make room for the next very important event. Documents can help to bridge the gap between what your witnesses remember or think they remember. So you need to be the master of the key documents in your case as part of mastering the facts in order to prepare your witnesses for their depositions. Another key point here, one that is beyond the scope of this presentation, is that you need to ensure that both your client generally and the individual witnesses you will be representing in their depositions have fully complied with their discovery obligations as part of the process of mastering the facts. This, of course, is critical in today's world, so I'm sure you are already well aware of the requirements and challenges associated with searching for and producing documents stored both in paper files and electronically. I would pause only to note a specific issue I've found with more senior executives, and I will generalize a lot today when speaking about senior executives, even though every witness is different. But in general, I found that senior executives don't always do the best job of searching for their documents, whether stored in paper files or electronically, for a couple of reasons. First, they're busy people, and as a result, they may or may not be giving your litigation hold or your request that they search for responsive documents as much attention as they should because they think they have bigger things on their plate. We will suggest some things later that you can say to use to scare straight any senior executives that aren't inclined to take your case as seriously as they should, but for now, recognize that part of that lack of care or interest often manifests itself in a lack of attention to discovery compliance. Second, senior executives very often will delegate the task of searching for documents to an assistant or perhaps even to their entire group to handle if it's someone who has a large number of direct reports. I've seen cases where a senior executive simply forwards a document request directed at him or her to a long list of subordinates with a request to, quote, take care of it and let me know if you need anything from me, end quote. That really presents a challenge because often an assistant or even an executive assistant isn't going to know everywhere that his or her boss has documents, and relying solely upon a group of subordinates to find all relevant documents without providing specific guidance or follow-up is a recipe for disaster. As a result, you may face a situation where the senior executive you are defending on deposition didn't do a great job of searching for documents, and you will end up with some gaps based upon what the company itself produced or others within the company produced that show that your senior executive was copied on a document or otherwise extensively involved in whatever the meeting or other event was. Unfortunately, in many cases, those gaps will make themselves known in a deposition when the other side's lawyer is questioning your witness very thoroughly about what he or she did specifically to collect all responsive documents. As I said, what steps you need to take to ensure discovery compliance is beyond the scope of this presentation. There are many, many other CLE presentations you can watch on this topic. And so I would just emphasize here that each and every witness needs to be prepared, and this likely even more so necessary for senior executives, to talk in detail at his or her deposition about what he or she did to collect all responsive documents. It's no longer the case that you can get a pass on that sort of stuff and just have the witness say, oh, my lawyers handle it, or oh, our general counsel is the one who's responsible for that. Everybody who sits for a deposition in today's world needs to be prepared for extensive questioning in this area. And so you certainly need to do that with all of your witnesses that you prepare, including the more senior executives who might have more exposure because they didn't take the time or put in the effort to do as thorough a search as they should have. I also would note that discovery compliance includes reviewing the comprehensiveness of the discovery responses and interrogatory responses you provided on behalf of your client, in addition to the documents you produced in the document production itself. It is generally considered fair game for any witness to be asked in a deposition about responses to requests for production or interrogatory responses. So you need to make sure that you've done a good job of responding to the discovery that's out there and preparing your witnesses in case they get deposition questions on this topic. The reason for my advice on this point about discovery compliance should be obvious to an audience of litigators, but I will say it anyway. A lack of documents or a lack of a thorough search for documents can turn a small, meritless case into a real problem if you have exposure in terms of failing to preserve documents that you were supposed to preserve or failing to do a thorough search for documents. Those CLE presentations I mentioned on discovery compliance no doubt will cite a number of examples of judges sanctioning parties for this, so you would need to avoid it at all costs. You really can lose the leverage in a litigation if you have a discovery compliance problem. You may have a small, meritless case that you feel very confident about, but if it turns out you didn't do a great job of searching for your documents, the leverage shifts and all of a sudden you have a big problem that you may have to throw money at in order to get rid of the case. The same is true if you want to press the other side for documents that they were supposed to have provided in response to your document requests. If you live in a glass house with regard to discovery, or if your witnesses provide unhelpful testimony on this topic in their depositions, you're going to have trouble making your case for sanctions against the other party in the case for any failures to produce responsive documents. One other terrible potential consequence of failing to produce all responsive documents prior to a deposition you are defending is that a judge or magistrate may require your witness to sit for a second deposition once all responsive documents have been produced to the other side. I can tell you with confidence that there is nothing a witness likes less than sitting for a deposition and then having to sit for a second deposition. I also will tell you that even if the fault for failing to produce the documents at issue lies squarely with that witness or with others at the company and not with you or your law firm, it's always the lawyer who is defending the witness at the deposition who gets blamed when a judge or magistrate orders a second deposition. So you must do everything you can to anticipate discovery compliance problems and to solve them so you can avoid the second deposition scenario at all costs. The final topic under mastering the facts is to ask your witnesses about potential impeachment material. I'm going to talk in just a second about this in more detail, but in today's world, that means Facebook, it means YouTube, it means TikTok, it means X, formerly Twitter, it means Instagram, it means any blogs, etc. It's now a good idea to have a laundry list of questions to ask any witness. Do you have a blog? Do you use TikTok? What about your Facebook page? Because now that stuff is out there and it's very easy for anyone to get a hold of it. You can bet the other side's lawyer in your case will have ready access to that stuff, and you may be, unfortunately, surprised about some of the things that your witnesses choose to post on Facebook or choose to tweet. Of course, it's much better to know in advance that you have bad facts that you need to deal with, rather than find out about them for the first time during a deposition. So it's important that you ask these questions so you can prepare your witness on how to handle those bad facts. Before we leave the topic of mastering the facts, let's focus on senior executives, some critical points that you need to pay attention to in this area. The first thing is that you need to be sure to obtain all handwritten notes from your witness. Recognizing that every person is different, you'll have some witnesses who are pack rats that save every scrap of paper, and you ask them to produce their files and they've got boxes of files, and no doubt you'll have other witnesses who have nothing at all. I would say in general, senior executives tend toward the latter camp more than more junior folks. That is because in the hierarchy, if you're the most junior person on the team, you're the one who's expected to have all the backup documents, all the memos, all the binders, etc. If you've been to a board meeting, you've seen the directors walking in, the CEO walking in, and none of them are carrying anything. They just sit down at the table and they hear presentations, and maybe someone hands them a binder with copies of those presentations or backup documents, but often they leave the meeting without taking the binder with them, and so no documents are being retained by the director. Again, everyone is different, so your senior executive may have a ton of documents, but chances are you're more likely to face a situation where your witness has none or very few. In that case, you need to guard against the situation I referenced earlier, where you're missing documents that should have been produced, which risks having your witness being recalled for a second deposition, or perhaps more likely, one of your key witnesses in the case who happens to be a senior vice president of X and had direct involvement in the matters at issue in the lawsuit doesn't produce anything from his or her personal file. It may well be the case that he or she has nothing, but you really need to press them to make sure they have looked absolutely everywhere and that you have absolutely everything, including any handwritten notes that they may have taken. I'm talking to litigators here, and I'm sure we've all had many cases where a handwritten note becomes very important in a case. Often, the handwritten note in question is some cryptic scribbling that was made many years ago by someone who doesn't really remember what he or she meant by the note. Handwritten notes are also uniquely susceptible to multiple interpretations. So you'll have the plaintiff positing something that he or she really likes, and you'll be suggesting something entirely different because it favors your position. For this reason, handwritten notes can become a big issue in your case, even if they don't deserve to suck up so much airtime. And it's really important to have those notes so you can prepare for that debate and to really press to make sure that you've collected everything that the client has. This brings us to our final topic in this section, which is avoiding senior executive impeachment horror stories. This goes back to asking your client about Facebook, asking your client about X, asking your client about TikTok, because it is truly shocking, particularly to those of us from an earlier generation, the extent to which people today are willing to share information about themselves online. The sad thing, as we get older, is that it's no longer just those crazy kids who are oversharing online. It's the 30 and 40-somethings who grew up in that culture and who are now among the senior executives you may find yourself representing. Oversharing online certainly leads to horror stories, and I've referenced a couple of them on the slide. In one case, a very senior executive posted on Facebook a picture of himself and his girlfriend attending a pimp and prostitute party. That's the sort of thing that the other side's lawyer can very easily find. And if there's an issue in the case, let's say it's an employment case and there's an allegation of bias on the basis of sex or discrimination or harassment, that photo might prove to be very embarrassing to your witness and also be used to suggest that he exhibited bias. As bad as having a photo like that out in this world is, it's far better for you when you are preparing a witness to know about that stuff in advance than to be surprised by it during the deposition. Unless your client reveals it to you, or you find it yourself by searching the internet for such material connected with your client, which isn't a bad idea to help protect the client, it will be a surprise to you because the other side's lawyer is going to obtain it outside the discovery process. Another impeachment horror story involved a senior executive who was blogging in support of Proposition 8 in California, a ballot proposition that defined marriage as only between a man and a woman. And that blog was used against him and his company in a case where the plaintiff was alleging sexual orientation discrimination. While these sorts of unfortunate personal facts are never going to be good for you in the case, the point is that you really need to know if they exist in advance so you can be prepared for them and so you can prepare your witness for them. Our final bucket of tasks under the topic of lawyer preparation is identifying key players. You need to figure out, based on your understanding of the case, who the key witnesses are. Now, it may be a mix of people who are still at the company today and people who have left, but through your various sources, your contacts at the company, the documents you've collected, etc., you should identify who the key witnesses are, and in general, you want to interview those key witnesses separately. The main reason for that is that you want to avoid cross-contamination of their testimony. You want to hear from each of them separately because you want to get independent answers from each of the witnesses, because in that way, you'll have heard one story from one witness, and you'll like it if that same story is confirmed independently by a second witness. This is distinguished from a case where you have both witnesses sitting there together, and one person says something and the other person tends to agree, particularly if one person is the boss and the other person is the subordinate. Subordinates are not likely to disagree with the boss, even if they have a different take on something. Even if the person would not hesitate to disagree with the boss in a business meeting or most other settings, you'll find that in an unfamiliar context, such as sitting in a conference room being interviewed by outside counsel in connection with a lawsuit, subordinates tend to disagree a lot less with their bosses. As the lawyer defending the case, you want to know each witness's independent version of the key events. The other important reason why you want to interview witnesses separately is because you want to avoid any perception that you got everybody together in a room to get their stories straight. Obviously, the attorney-client privilege protects what you say when you're meeting with your witnesses to prepare them for their depositions because they are employees of the company who is your client. But the privilege doesn't extend to who was present, so the facts about who was in the room, how long the meeting lasted, etc. are not privileged. That certainly would be something the other side's lawyer may ask about. So if you hypothetically called 5 employees together into a room, and there were 3 or 4 lawyers there, and you were preparing those witnesses for their depositions, the other side could draw the inference and make the argument that you got everyone in a room so that you could get their stories straight. That's what you want to avoid. On a related point, one thing you should do with the witnesses you prepare is give them some understanding of the attorney-client privilege so that they can work with you to effectively respond when questions they are asked in a deposition come up. Obviously, witnesses don't need to know much about the attorney-client privilege because anything that comes up in a deposition that implicates the privilege, you can interject and assert the privilege on behalf of your client and instruct the witness not to answer. What you should tell the witness, though, is that if he or she has any concern during the deposition that a question being asked seeks information that is sensitive or privileged, the witness should stop and ask for a break to discuss their concerns about a potential privilege issue with you. That's certainly the right advice, and you never want a witness making any kind of privilege calls, so that's the first thing to make sure your witness understands. I also find that it's useful in advance to let the witness know that certain facts are not privileged, so they can go ahead and answer questions about those facts without having any concern that the privilege might apply. For example, you should tell the witness that the privilege doesn't extend to basic facts about your interviews, such as when it was, who was present, how long it lasted. The substance of what was discussed and what documents the witness was shown are privileged, but these basic facts are not. And it usually is best to prep the witness that he or she can answer questions in this area without needing to ask you for a break. It makes for a cleaner record if the witness answers these basic questions and then pauses so that you can object on grounds of privilege if the other side's lawyer starts to ask about the substance of the meeting. I think this works best because if a witness is only told that there is this thing called the privilege, and it generally covers your interactions with lawyers, they will get very nervous in the deposition when the other side's lawyer starts asking them questions about how many times they met with you, who was there, where did the meeting happen, which is unnecessary. Rather than have them be concerned about that, it's a better practice to prepare them along the lines of something like the following. Look, you can answer questions about who was there, when it took place, how many times we met, but when it comes to what we talked about or what documents you were shown, that's where you will pause and I will object on grounds of privilege. In my experience, that's a good way to handle it so that you don't get worried that the witness gets worried when questioning starts to go in that direction, as it almost always will at some point in the deposition. The other key piece of advice here is when you are meeting with the witness, it's really good to ask open-ended questions. Once again, while this is a good idea for most witnesses, it is perhaps even more important for you to do with more senior executives. While asking open-ended questions might help you discover key facts that you didn't know to ask about, so in that sense, it's a good practice for all witnesses. Often with more junior folks, your mission with that witness is very narrow. For example, you're talking to somebody in the finance group because there is an issue about some invoice, and you just want to know what this invoice is that we're talking about, did you prepare it, etc. Your goal with this witness is simply to find out or confirm something very narrow, so you may go into those interviews in confirmation mode, just asking the specific questions that you're interested in, because it's a ministerial issue that really isn't subject to debate or interpretation. When we are talking about more senior people, those executives tend to have a broader swath of responsibility and generally a bigger perspective on the case. With these witnesses, it's more important to focus on asking more open-ended questions because it's much more likely in that case that you're going to learn things that you don't know. One helpful way to think about interviews with senior executives is that you're now acting more like the lawyer who is taking the deposition, in terms of asking open-ended, discovery-type questions, with the goal of eliciting some facts that you may not know, which may be helpful to you in terms of understanding the entire case as a whole. Junior folks rarely will have the same breadth of knowledge about the company or the issues involved in your case as senior executives, so be sure to take advantage of that when you are prepping more senior folks for their depositions, as it could lead you to discover important facts. On a related point, you should advise each of the witnesses you are preparing not to discuss the lawsuit with anyone other than their counsel. I put this in the category of nothing good ever comes from discussing a lawsuit, similar to nothing good ever comes from discussing an HR issue. If you're having some HR issue in your company, the worst thing that can happen is people talking or emailing about it, so-and-so employee or so-and-so issue. That just always creates bad facts, and most, if not all of those emails will not be privileged. It's great advice for everyone that you're preparing to instruct them not to discuss or email about the lawsuit with anyone. Often, senior executives have more experience being involved in sensitive matters, and absent your instruction, they might feel more comfortable having those kinds of conversations with others at their level. So it's really important to instruct them that that's not something they should do when you're talking about litigation. Litigation is a different animal from other sensitive matters that senior executives deal with, and you should make sure they understand that and encourage them to follow your expert advice in this regard. Our next topic is a meaty one: what to do about former employees. You certainly want to think about, and if possible, finding and interviewing former employees who were involved in the facts that are at issue in your case. Often, you'll find that because of changes in the company's structure or changes in its business, whatever is at issue in your case that no one has any current involvement with that. For example, a line of business that was discontinued or a particular practice that was replaced by some new procedure. When that happens, it may be really important for you to be able to understand how things worked at the company 5 years ago or whenever the key events took place. And the only way you can do that now is with the help of former employees who were there at the time. When you make the decision to go out and talk to a former employee, that also raises the question whether you can or should represent them in addition to representing the company. There are a couple legal issues to consider here. The first is whether there's a conflict of interest between the former employee and the company. You can't represent a former employee if that former employee has a conflict of interest with the company that you represent, because such representation would be prohibited by the legal ethics rules. Often, in an employment case, let's say it's a sex discrimination case, the alleged harasser is the former employee, and in those cases, there may be a legal issue in terms of having a conflict representing that employee, particularly if the company's position is going to be that he or she acted independently and contrary to all of the training and instructions that the company gave. That's the first issue, and of course, a critical one to consider at the outset. The second issue to consider is whether the other side can contact the former employee. Everyone knows that if you represent a company, the other side's lawyer can't contact anyone in that company directly. They have to go through you in order to do that. But if the person is unrepresented in the matter, the other side's lawyer can contact that person directly. In the case of a former employee, you're kind of in the middle ground, because until you or some other lawyer is representing them, they are just a party who is unrepresented in the matter. There's also the practical question about whether this former employee would voluntarily talk to the other side's lawyer. So if you have a situation where a former employee works for a close customer of your client, or there's some other strong relationship there, you may have more flexibility in terms of whether you want to represent them in order to prevent the other side's lawyer from being able to speak with them informally and prior to any noticed deposition. I'm going to talk in a minute about a lot of good reasons to represent former employees, but because there is a cost associated with that, if you have reasonable confidence that the former employee is still very loyal to your client and is in a position where he or she is not likely to talk to counsel for the other side outside of a formal deposition, that's one factor you could consider in terms of whether you feel that you need to represent them in this case. On the other hand, if it's a former employee with whom there is no current relationship, and certainly somebody that the other side's lawyer could call up, and if that person wants to agree to sit down with the other side's lawyer, that could be a bad situation for your client. In that situation, you may want to strongly consider representing that person and incurring that cost in order to require that the other side's lawyer go through you with any communications to that former employee. Being able to control access to key former employees is often a good reason to opt to represent a former employee when you have discretion to do so. The other issue here is the tactical issue I alluded to with the example of the potential harasser. Even if you don't have a legal conflict with that person, which would prevent you from representing both the company and that witness, but you also have the tactical question that if you get into a trial, of course, trials are rare, but if you're there at counsel table at trial and you're sitting right next to the alleged harasser, that's going to give a perception to the jury about whether the company is supportive of that person or whether they're distinct. It's very difficult to create any kind of separation between the individual and the company if they have the same counsel. So there's a tactical issue here that you need to consider in every case because you never really know which ones end up at trial. With all of that said, in the majority of cases, the balance will tip in favor of representing former employees because you have increased control over how that person's testimony is going to come out. You're able to prep them, the other side's lawyer isn't able to talk to them without your permission, etc. For this reason, the scales generally will tip in that favor, but these are the sorts of issues that you need to ask yourself both legally and tactically before you make that call. The other thing that often makes a huge difference is, did the witness leave the company on friendly terms? A lot of people don't leave on friendly terms. They're a former employee for a reason. Because there was some falling out or some change in leadership, and they were let go, or maybe just mass layoffs that included this person. In some cases, this can be a very difficult situation for you to navigate if you're the outside counsel for Company X and you're calling up a former employee of Company X who was let go and feels that he or she shouldn't have been let go. A couple ways I found in my experience that you can deal with that is taking advantage of the separation that you have from the company. You're outside counsel and not in-house counsel, and you can diffuse a little bit of that kind of anger by building your own personal relationship with the witness. In a lot of cases, being outside counsel makes your job harder than in-house counsel because you aren't as trusted with current employees. But I think with former employees, you can take advantage of being outside counsel and use that to build your own personal relationship with the former employee. One of the things that you'll find, and those of you who've done a lot of depositions know this, some of the closest relationships that I've made in terms of attorney-client relationships have been representing witnesses in depositions. If you're able to prepare a witness well and have that witness come out of a deposition having done a great job, you will build a client for life, and sometimes even a friend for life. I already told you that I met my wife preparing her for her deposition, so I know what I'm talking about. Sitting for a deposition in a case involving your employer is one of those experiences in life that is very stressful for the witness. And if you can be one of the people that helps them make it through and does a great job for themselves and for their company, you're the hero and you've made a client for life. So that personal relationship that you can build helping somebody get ready for an unpleasant experience like a deposition can help you many times with former employees who may be disgruntled. The second thing that helps, maybe not as much as the first, but it's significant, is that you have the ability to pay a former employee for his or her prep time. Offering to pay somebody if they are taking time off of work at their regular hourly rate of $200 an hour or whatever for their prep time is another way that you can mollify some of their unhappiness with the company. Importantly, you have to be aware of the ethics rule. You can only pay somebody for the reasonable value of their time spent preparing for and testifying in a deposition, and you can't pay them anything in excess of that. But within the scope of that rule, it's a real benefit if somebody has to take time out of their lives to prepare for and sit for a deposition related to a company that they used to work for 3 years ago and weren't so happy about. It's another way to get over some of those concerns. In addition to the ethics rule, The witness can be asked about how much the company is paying him or her, and you should be sure the other side's lawyer will ask that question. So you need to prepare the witness on that, and also to be ready to make the case that whatever the company is paying the witness is eminently reasonable in light of what the witness currently earns from other work. It could be seen as excessive to pay the witness based on his or her salary when he or she worked at the company, if he or she is currently unemployed and hasn't worked in years. So this is definitely something that you have to pay close attention to in terms of how it will play when it comes out. All of that said, you get much more in terms of benefits, more time from the former employee to prep, more attention to the matter, and less antipathy toward the company if you choose to pay them than you suffer in downside. This is another point where we want to focus in on senior executives before we leave the topic of identifying key players. One of the key issues for senior executives relates to joint representation by the company's counsel. Many senior executives have employment contracts, so your company may be under a contractual obligation to represent them in any litigation arising from their time at the company. Subject, of course, to a legal conflict of interest, in which case it would just mean that you couldn't be the one to represent them, and they would have to get their own counsel that the company would pay separately for. As a result, the question we discussed about whether to represent the former employee may have already been decided for you by the terms of their employment contract. Severance agreements are another place where the company has a duty to represent the former employee, and also where the former employee may have a duty to cooperate in future litigation. So you need to check those, as they could be helpful to you in securing that cooperation. In addition, the severance agreement might have provided for a cash payment or other consideration to the former employee for them having given the company a release. In that case, it's very likely that the severance agreement is going to be responsive to a document request, and likely something that you will have to produce. It's also an area where you will need to prepare the witness about how to handle questions about the terms of their separation, whether they're obligated to cooperate with the company, how much they were paid, because you can see these sorts of facts would be the things that the other side's lawyer might try to seize upon in an effort to argue bias. You can imagine the other side's lawyer asking, "Isn't it true that you're only here because the company paid you $2 million to settle out your own claims against the company? Or isn't it true that you're contractually obligated to be here and support the company's position?" The facts are what they are, but you have to be ready for that line of questioning when you're talking about a senior executive who has a severance agreement. I mentioned this before, but you certainly have a lot more control over a former employee if you do represent them jointly with the company, and therefore you're able to prepare them and you have access to them, including on sensitive lines of questioning like the ones I just outlined. In most cases, that is a critical difference, and it almost always, in my view, justifies the additional cost of providing the representation of former employees. The flip side of this, a disadvantage of jointly representing former employees, relates to the former employee's discovery obligations. If you're representing the company, and in today's world, discovery obligations are very broad in terms of not only physical records, but also electronic records. And if you're undertaking this massive production on behalf of the company, and you also happen to represent some former employee, you may have a little bit of trouble trying to limit the scope of documents or electronic files that are produced from that former employee. Let's turn now to the first topic under witnesses, which I've labeled preliminaries. We've talked a lot about what you as the lawyer need to do, how you need to prepare, some of the key issues that you need to address. And so let's talk now about what you need to do with the witness himself or herself. The first thing when you sit down with a witness is to describe the case, who the players are, and what stage of the case you're in. For example, has the complaint just been filed, or are you already at the end of discovery? Have you already passed summary judgment? Are you headed for trial? Where you are in the litigation is more important for senior executives than it is for junior executives, because in most cases, junior folks don't need to know the whole picture because they're there for some narrow focus, and it's appropriate to keep them relatively narrowly focused so that they don't hear something about some other part of the case and then they feel like they know something that if they are asked about it in a deposition, they might be tempted to speculate, because you definitely don't want that to happen. For senior executives, by contrast, I think it's generally better for them to have a sense of the case overall and where their particular role fits in, so that it's more likely that if something unexpected comes up in the deposition, and that always happens despite your excellent preparation. They know at least a little bit about the overall context in which they are testifying, as that generally will produce better answers and less speculation. To be clear, you certainly don't want to educate a senior executive or any other witness about areas of the case about which they don't have personal knowledge or experience. Of course, I'm making a distinction here between a Rule 30b-6 type of a deposition, where the witness is testifying on behalf of the company, and so you have an obligation to educate the witness about certain topics. Outside of that unique context, for your normal deposition and your normal witness, you don't want to educate them about areas where they don't have personal knowledge. Remember, you are playing defense in a deposition, and your goal is to prevent the other side from scoring points, not to score points yourself. Now, for every rule, there is an exception, and there may be circumstances where you have to adjust that a bit. For example, if you have a former employee who left the company, and there is some important part of the business or important facts in the case that you need someone on behalf of the company to be able to testify about, and no current employee has knowledge of that, there may be narrow instances where you need to educate the witness using documents from the company's files to provide that testimony. Again, this is very rare, and the general rule is to tell your witnesses that if you don't know something, you say, "I don't know," or "I don't recall," and you don't speculate about what others in the company may have known or did or said. This is the standard advice, and you should not vary it except in the rarest of cases. The final general point here before we focus again on senior executives is note-taking, and the advice here is equally clear. Don't let your witnesses take notes in a prep session. You don't want witnesses taking notes because the argument is going to be that those notes were refreshing the witness's recollection and they should be produced. And you definitely don't want notes that your witness is taking in a deposition prep session to be produced in the case. I've seen lawyers handle this in a few different ways, but I don't like any of those ways as much as just insisting that your witness not take any notes during your prep sessions. Some lawyers allow the witness to take notes, and then they say that it's a memo to counsel and they take it away for some period of time. I don't like this approach because the witness's notes are in fact notes and not a memo to counsel. And even a memo to counsel would need to be put on a privilege log, which just invites the same fight over whether the notes should be produced because the witness used them to refresh his or her recollection. My experience is that if you can get the witness comfortable with you and feel that if there is something important, you're going to review it again with him or her before the deposition, they don't need to take their own notes. Take it from me, witnesses taking notes during your prep sessions is never a good idea, so just don't let them do it. Turning back to senior executives to spotlight some more issues and concerns that are unique to them, the first one here is probably the most important. You must get them to understand and believe that saying "I don't know" in response to a question, or many questions in a deposition, doesn't mean I'm stupid. This is maybe your hardest task with senior executives, but it's absolutely critical to having a successful deposition. As you get more senior in life and in business, you tend to know more, and you tend to think you know even more than you actually do. If you're an expert in something, maybe a scratch golfer or a gifted musician, you actually know a lot more than most people on a topic, and sometimes, maybe you even know everything that there is to know on that topic. Most other times, you only think you know everything. Just ask your spouse or significant other and they will set you straight. In a deposition, it's really important, no matter who you are, to only testify about those facts and events of which you have personal knowledge. Personal knowledge means that you were there. You had a conversation with someone. You read a document and you remember now what that document said without reading from the document. You were involved in some event in some way. Senior executives tend to know a lot about what's going on in the company generally by virtue of their positions. But you don't want them to be testifying about any of that if they don't have a basis for it in terms of their personal knowledge. Not only can they be impeached because they had no personal knowledge and therefore were simply speculating, the greater risk is that the speculation will be helpful to the other side because it contradicts what other company witnesses have testified to or is inconsistent with the company's current position. Far from wanting to impeach your senior executive when he or she speculates, The other side likely will want to lean into that speculation because it helps their case. Refusing to speculate in a deposition is difficult for all witnesses, but it is particularly hard for senior executives. How many times have you heard a CEO say, "I don't know," in response to a question? Certainly not often enough, and maybe never. It's clearly true at the CEO level, and it's true at every level below that. So your SVPs, your VPs, all are going to not want to say, "I don't know," because they think that's the same as saying, "I'm stupid" or "I'm unprepared." They can't imagine ever saying that in a business meeting, and so they can't imagine saying it in a deposition, which seems to witnesses who have never been deposed before to be similar to a business meeting. This is one of the areas where you really need to work hard with the witness to explain, look, this deposition is not a test of how much you know or how smart you are, and it's not a situation where you can or should be able to answer every question that you're going to be asked. That is not the purpose of a deposition, and in fact, in a deposition, if the witness is doing it correctly, the answer to many, many questions is going to be, "I don't know." That's simply because you are one person and you were not involved in everything that a company was doing over a 10-year period where this litigation relates to. This is a real challenge for all witnesses and probably the biggest challenge in representing senior executives. If you can teach your witness to answer "I don't know" in response to questions where that is the correct and truthful answer, almost everything else you do to prepare the witness and the deposition itself is going to go fine. The second biggest challenge for senior executives is checking their ego at the door. Similar to the first point, but also a bit different, senior executives are the ones who have the big jobs, they make the big salaries, they're used to getting their way, they're very successful in their lives, and they probably feel pretty good about all of that. Now, you put those folks in a deposition setting where the other side's lawyer, depending on his or her style, may be going at them in an aggressive way and trying to challenge them. When that happens, the other side's lawyer may succeed in putting senior executives in a defensive position where they want to strike back at that and to prove that they're better than the lawyer who's questioning them. Being challenged by someone that you don't respect can cause a senior executive to fight to validate his or her ego and sense of self. It's not only aggressive lawyers on the other side that can present a problem for senior executives as it relates to their egos. Another very effective approach taken by some lawyers is to try to be the witness's best friend and to get the witness to just sit there all day like a professor and expound on this or on that. In other words, rather than attacking the senior executive's ego, the lawyer is stroking it by asking the senior executive to teach him everything he needs to know about X, Y, and Z. This leads to a ton of volunteering, speculating, summarizing, and a host of things you don't want your witness to do in a deposition. If your senior executive is good at these things, he or she might not make a great witness at trial, but depositions are another matter in terms of how you want your witness to handle questions from the other side's lawyer. Both of these problems are ego-related, and you need to do your best to have your senior executive check his or her ego at the door as much as possible. Otherwise, you're going to have a really tough day in the deposition, no matter how much other preparation you do of your senior executive. The next challenge for senior executives is taking the deposition seriously and devoting enough time to prepare. Senior executives are very busy, and they tend to think that they know more about their business than any lawyer on the other side is ever going to know. That's why most of them will come to your first prep session thinking, I can sit there for a couple hours and answer whatever silly questions this person's going to ask me, and I'm going to be brilliant, and I'm not worried at all about it. The problem is that a deposition is a unique procedure that is wholly unlike a business meeting, because deposition testimony can be twisted, it can be excerpted, and it can be used to imply things that the witness never intended. As a result, there's a particular way you need to approach the deposition, and if the witness isn't appropriately concerned about it, it's likely they're going to be careless, and you may end up having a lot of bad testimony. For senior executives, there's generally a need for a little bit of scaring them straight in terms of what a deposition actually is and what can go wrong if they are careless in their deposition testimony. You should let them know that careless testimony can be used against the company in a summary judgment motion and at trial, and that testimony can make you look very bad. It can make the company look very bad, and so the stakes are very high. That's why you need to pay attention to this. That's why you need to give me enough time to prepare you, and that's why you need to take this seriously. While it's clearly self-serving, you want the senior executive to give you all the time you need to prep him or her. All of this is 100% true in terms of what can go wrong if the deposition goes south. Most senior executives exhibit this kind of behavior, but sometimes you'll have the opposite, a witness who's really scared about the deposition. Let's say it's an employment case and the senior executive was the supervisor of the person who's claiming discrimination or claiming they were terminated unfairly for some reason. That person may feel that they're being attacked personally and that their reputation is on the line. They may worry that the company could lose millions of dollars if these claims are sustained, so they may be quite scared and they may feel a lot of pressure to give a good deposition. In that case, you need to take the opposite approach. You need to calm them down. You need to reassure them that if you follow my advice and you devote enough time to preparing, you're going to be fine. You have to adjust your advice to the type of witness that you have. But with senior executives, more often than not, you tend to find people who aren't as worried as they should be about their deposition, and they're not willing to give you the time or to take it as seriously as they need to. So they need to be scared straight more than consoled, at least at the outset. Covering the basics of witness prep without talking down to the witness is another challenge with senior executives. We're going to talk in a few minutes about using a deposition prep video to help you prepare witnesses, and this is one of those areas where a deposition prep video is especially helpful. When we're talking about senior executives, your CEOs, your senior vice presidents, your board members, or whoever it is, their time is very valuable, and during any given week, they've already got a lot of meetings on their schedule, and you're coming along and trying to get 2 or 3 hours or potentially even more with them, maybe broken up over several days if necessary. Whatever time you're able to get, the notion that you'll be sitting there and saying, don't volunteer, don't speculate, listen very carefully to the question and answer only that question, read every document closely, feels a little rote, and because this advice is very basic, it can seem like you're talking down to your witness, particularly if he or she is a senior executive. This creates the very real risk that they're going to tune you out, and that would be a huge disaster because this advice, as basic as it is, really is critical for your witness to give a good deposition. One way to get around that is to use a deposition prep video that covers the basics and that the witness can watch on his or her own time, so that when you're in the room with the witness in those couple hours of prep time, you can really focus in on what are the critical issues in the case, what are the critical documents, and you can do some role play and you can do some mock questioning. That's a much better and higher use of your in-person time than spending a lot of that time on the basics that a deposition prep video can cover off for you. This is true for all witnesses, but it's particularly true for senior executives who have limited time and are more likely to perceive the basic advice to be condescending, even though they need to hear it as much and perhaps even more than junior folks need. My next piece of advice is to use the sophistication of senior executives to your advantage. In fact, I would go so far as to say that the ability to use the sophistication of senior executives is probably so much of an advantage, if done right, that it outweighs all of the disadvantages that senior executives often bring to the task of preparing them for their depositions, such as they don't like to say, I don't know, they don't like to search for documents, and they don't want to give you any prep time. When we're talking about senior executives, and there are exceptions here, but generally this is true, they tend to be very sharp because you don't get to the top of your company without having some smarts, having some experience, and having been around the block a couple of times. You should feel free to use that to your advantage when you are preparing them to testify on deposition and in the deposition itself. The story that I like to tell here is when I was doing the Oracle versus PeopleSoft case at Davis Polk, we represented Oracle, who was doing a hostile takeover of PeopleSoft, and I got to work with Larry Ellison, who founded Oracle, is currently its chairman, and at the time was its CEO. He is also now a billionaire many, many times over because of the company that he built into Oracle. I helped to prepare Larry for his deposition and also his trial testimony in that case. What's amazing about someone like Larry Ellison is he's the smartest person in the room by a factor of 10. He's probably the smartest person in the state, probably by a factor of 10 as well. Watching him handle questions from the other side's lawyer was one of those depositions where you just sit back and you let your witness handle everything, because Larry understood the process, knew the case better than anyone, and was thinking 10 steps ahead of everyone. Now, the challenge, of course, is that there aren't that many Larry Ellisons out there, but there are a lot of people who think they're Larry Ellison, and they think that they know everything there is to know. And that's pretty dangerous when we're going to talk about that person going into a deposition in an important case. The key to managing this risk with senior executives is presenting them with the necessary background of the case, explaining to them what a winning deposition looks like, as opposed to trying to win the case. If you explain the task, and if your senior executive is smart and experienced in important deals and sensitive situations, they can do a great job. Indeed, some of the best depositions I've ever seen were witnesses who were very senior executives. Once they understood how to play the game, they were better at the game than anyone I'd ever seen. That's a great thing and something to be grateful for with senior executives, because when you're preparing witnesses at some of the more junior levels, your best hope is that this person is going to do a decent job in the deposition. By that I mean, don't go off on tangents, don't go beyond his or her scope of authority, don't testify about matters in which he or she has no personal knowledge, all of which are huge danger areas. If you've got a reasonably good lawyer on the other side, they're going to get some stuff out of that witness. It's just the nature of the beast. And more junior folks are less able to stick to the advice you've given them than senior folks in general. If a senior executive is really well prepared, is really sharp and really experienced, and stays within his or her designated area, it's really tough for the other side to get much in the way of helpful testimony out of that deposition, much less the sort of colorful sound bites that can be really helpful to them and bad for your client. The next thing for senior executives that can present a challenge rather than an opportunity is limiting themselves to testifying from their personal knowledge and not what the company, in a collective sense, knew or did or believed. This is very standard advice you're going to give to every witness, something like, in a deposition, you always should be speaking just for yourself, and you shouldn't be speaking on behalf of the company. It's just harder for senior executives because they do know more than most employees, and often they're used to speaking on behalf of the company. After all, it's the senior executives who represent the company in business meetings and at speaking engagements, so this one's a little bit harder for senior executives to follow. The best way to teach witnesses about the risks of testifying on behalf of the company is to focus on how the other side can use innocent mistakes to suggest something nefarious. Typically, I would say to the witness something like, you may have a good sense of how your company works because you're an operations executive, so anything in the operations area, you know soup to nuts. You'd also know a lot about finance because you work closely with the finance team, and you know a lot about your sales group because obviously you support sales efforts. But for you to testify about something that's very in the weeds in the finance area, for example, how does the company amortize that particular expense, or how does the company create that particular accrual, can easily put you in a spot where you know just enough to be dangerous. You don't want to go there because there are finance experts in the company who have knowledge of what the company actually does and why it does it, and they should be the ones answering those questions and not you. That's how I like to describe it to witnesses, and I think framing it that way is very effective. To drive home the consequences, you can add that the witness doesn't want in a deposition giving away any testimony that he or she is not absolutely sure about, because any kind of innocent mistake that you make gives the other side something that they can use to contradict others in the company who have given the correct answer. By your innocent mistake, you've created a conflict in the testimony between the company witnesses that can be used to suggest that the company isn't being truthful, even if it was an innocent mistake. I think that's how you handle senior executives who might be tempted to testify about what the company, in a collective sense, was doing or knew or didn't know. We'll talk shortly about using a deposition preparation video, so for now, I'll just mention that one great way to show senior executives, and really all witnesses, how to give a good deposition is to use a video. One of the challenges before there were deposition prep videos was, for a witness who's never sat for a deposition before, how do you describe what it is? How can you explain how the process works or really drive home what giving a good deposition looks like? Of course, you could tell them that there will be a court reporter taking everything down, there will be a lawyer on the other side who will ask you questions, and you should just give narrow answers. You should answer, I don't know if you don't know, etc. It's not hard to tell a witness these things, but unless the witness has been deposed before, he or she won't know how to answer questions in the context of a deposition and what a good deposition looks like. Put another way, it's the difference between being told what to do and seeing what to do and what not to do. And that's the unique benefit that a deposition prep video offers. Once your witness has seen someone in a deposition giving careless answers, speculating, guessing, talking about what the company knew or did, and then they see somebody doing it the right way, It makes all the difference because the witness knows, okay, I can emulate how that person who gave a good deposition did. That's really the critical benefit of deposition prep video, which we'll talk about shortly. But I mention it here because senior executives need to see what a good deposition looks like and be able to compare it to a bad deposition as much as any witness, and perhaps even more so because of the harm senior executives can do to your case if they give a bad deposition. Our next topic under witnesses is substance. Not at the outset, but once we're in the middle of the prep time, I like to ask witnesses, what worries you about this case or this deposition? Because the answer may surprise you. One example I like to give here is I once asked a witness this question, and the case was a commercial litigation between two big companies over a contract. And the witness responded, well, I'm involved in this divorce and it's really nasty, and is my divorce going to come up in the deposition? Of course, the witness's divorce isn't relevant at all and it won't come up, and so he was worried about something that he had no reason to worry about. And so you can really allay those concerns very easily. Understanding what worries the witness is often a good way to gauge their anxiety level, and they will be grateful to you if you can relieve some of that anxiety. It's also a great way to find out facts that you may not know. Let's suppose instead the witness says, well, I'm really worried about this memo where we admitted that our product was defective. And you may look at them and say, what memo? And then you found out about the memo. While the memo is a bad fact, it's something that you absolutely need to know about so you can take steps to counter it. For this reason, it's great advice to ask open-ended questions generally, not just is there anything about this deposition that worries you, but is there anything about the case that worries you, or is anything that I've said to you seem inconsistent with what you know, or have I said anything wrong? Asking those kinds of questions not only can put the witness at ease if he or she is worrying about things that aren't relevant, but also because you may learn things about the case that you need to know and didn't know until you asked the question. Another good technique is to have the witness tell you the story in chronological order. That is often a good way to organize your preparation because people tend to think about things in chronological order. Obviously, as the lawyer defending the company, you have a broader perspective on the case. Maybe it covers a 10-year period and you've got key events that happened in the beginning, middle, and the end. And this witness may have only been involved in the beginning or only involved at the end. For this reason, it's often very helpful to see how the witness thinks about it and what events he or she would include in a timeline to make sure you're aware of them. We talked in some detail before about whether to refresh a witness's recollection, and it is something you need to think about carefully before doing that. Generally, you don't want to refresh a witness's recollection because a deposition is a defensive exercise. If somebody truthfully doesn't know or doesn't recall the answer to a question in a deposition, that's the answer that he or she should give in a deposition. There are limited circumstances where you may need to refresh a witness's recollection. For example, if it was a critical meeting or a critical phone call or a critical decision, and your witness for whatever reason has no recollection of any kind of that event, maybe it was 10 years ago, that's where you have to ask yourself, do I really need this witness to testify about this, or is it I don't know okay? I think the default is I don't know is okay, but you have to put an asterisk there to deal with certain circumstances where having this witness provide fuller testimony might be needed. One downside of refreshing a witness's recollection is that when you do use documents to refresh a witness's recollection, you will need to produce those documents if they're not otherwise responsive. The rules in this area are complex, and you will need to check the specific law that applies to your case and jurisdiction. But as a rule of thumb, you start with the proposition that you're only showing witnesses documents that have been produced in the litigation. If that's your universe of documents that you're showing a witness, you won't be showing a document that hasn't been produced, because if it does refresh the witness's recollection, you would be required to produce it. Whether or not that requirement would extend to documents containing privileged information is once again something you would need to confirm based on the law that applies to your case and jurisdiction. Because there is a very real risk that you might be required to produce documents containing privileged information if the document is used to refresh a witness's recollection, the best practice is not to show a witness any document that wasn't produced in the lawsuit, such that privileged information wouldn't ever be a possibility, because those documents would have been logged as privileged and withheld from production on that basis. The next point, in terms of substance of your advice, is you're going to tell the witness to always tell the truth in his or her deposition. That, of course, is the most important thing in a deposition. And we've all seen clips from movies or TV shows where a lawyer in a deposition or at trial asks a witness, "What did your lawyer tell you to say in your testimony today?" And before the witness's lawyer can object, the witness blurts out, "He told me to tell the truth." Of course, those exchanges are staged for dramatic effect, and you'd always want to object and not allow your client to answer a question like that. But the point is, it must be crystal clear to the witnesses you prepare that your advice to them is to always tell the truth in their deposition. That is because there are serious consequences for witnesses who don't tell the truth in depositions, and not only potential sanctions, but potential impeachment. If your witness is lying or shading the truth in a deposition, that person's credibility can go to zero if the other side's lawyer finds out about it and is able to impeach him or her. For this reason, it's tactically the wrong approach, in addition, of course, to being unethical and illegal. Now, while lying is clearly the wrong approach, how the truth is presented in a deposition can be critical, and that's why deposition preparation is so important. Your witness must tell the truth, but if he or she uses colorful language or sound bites to describe what happened, that is going to be worse in general for you than if the witness took a just the facts ma'am type of approach. You need to advise your witnesses that they want to be very bland in their depositions. You don't want to use colorful language. You don't want to exaggerate. You don't want to answer in pithy sound bites. You just want to answer the question truthfully and to answer only the question that's being asked. Once you do that, you just sit there and wait for the next question. That's the advice that you need to give your witnesses when you're preparing them to testify. One of the best ways to make sure your witnesses receive and understand how to apply this great advice is to use a deposition prep video to help you prepare your witnesses to testify. As I've alluded to at the outset, my path to using deposition prep videos is a unique one that I want to share with you. For many years, I worked as a litigator at Davis Polk, where I prepped dozens of witnesses for depositions, and I'd never used a deposition prep video to help them with that. When I moved in-house at NBC Universal, I was still preparing witnesses for depositions, typically with outside counsel, and NBC Universal had an old deposition prep video that they used to help prepare their employees for their depositions. When I say old video, I mean old video, because the thing looked like it was from the 1980s, and it even was on a VHS tape, maybe even a Betamax tape. Despite looking very dated, I was surprised at how well it worked in terms of helping witnesses get ready for their depositions. I would show this old deposition prep video to witnesses, and they would really benefit from it, and I quickly realized why it was so helpful. The video showed a witness doing it wrong, by that I mean getting in trouble through honest mistakes, like speculating, in order to come up with an answer to a question he or she was being asked in the deposition, and then being impeached because the answer turned out to be wrong, and what could happen there in terms of what that testimony was being used against the witness and the company at trial. Then the video showed a witness doing it right, refusing to speculate or volunteer information, and the combination of these two visual experiences really helped the witnesses understand how a deposition works, how you should answer deposition questions, and what kind of witness you should try to be. In other words, I figured out what the secret sauce for deposition prep videos was, and I decided to write and produce a new video that would be even more effective at helping prepare witnesses to testify. The result was a deposition prep video called Deposition Testimony: 5 Simple Rules. As soon as we started using this new deposition prep video with clients, I was amazed at how much it helped them in their depositions. I followed the same general approach as the old video, with vignettes showing a witness doing it wrong and a witness doing it right, to make the comparison clear, but in all other ways, it's completely different. Our deposition prep video looks like a feature film with modern deposition and courtroom settings and superb acting. You don't watch it on your TV by putting in a VHS tape, who even has a DVD player anymore, much less a VCR. Now you access the video online from any desktop, laptop, tablet, or phone 24 hours a day, 7 days a week. In terms of cost, law firms can have access to the Deposition Testimony 5 Simple Rules program on either an annual all-you-can-eat basis or on a pay-per-view basis, where they only incur a charge when the program is used with a client. Some law firms prefer the pay-per-view model because they choose to pass the cost through to the client, similar to how they would pass through other charges related to a deposition, such as deposition transcript fees, videographer fees, travel expenses, etc. To find out more about how you can get access to the program, you can visit www.depositiontestimony.com. You're probably tired of me telling you how great the Deposition Testimony 5 Simple Rules program is, so now I'm going to stop and instead, we're going to show you just an excerpt from the program so you can judge for yourself. We're going to show you the first 25 minutes of the program. The full program runs 45 minutes in length, and that will give you a good sense of the program as a whole. To give you a quick summary of what you'll see, the program starts with a trial scene where a witness who gave careless testimony in his deposition gets impeached at trial. The reason we start that way is to get the witness's attention right away and remember what we said about the need to scare straight some witnesses who aren't worried enough about their deposition, and to get them to see the importance of what they're about to do so that they will pay attention to the rest of the program and take it seriously. After the trial scene, you're going to see the first 3 rules of deposition preparation, which are rule number 1, always tell the truth, rule number 2, don't volunteer, and rule number 3, don't speculate. As we say here in Hollywood, lights, camera, action.
Shannon Stevens versus Patterson, Baird & Company, United States District Court, trial, day 4. Shannon Stevens has sued her former employer, claiming she was fired because she is a woman. Pete Roberts, her former boss, is finishing his testimony on direct examination at the trial.
Mr. Roberts, why did Patterson, Baird & Company decide to terminate Ms. Stevens' employment?
Patterson Baird's revenues were down substantially and we needed to cut costs. Unfortunately, Ms. Stevens was one of several underperforming employees who we had to let go.
Did the decision to let Ms. Stevens go have anything to do with the fact that she is a woman?
Absolutely not.
No further questions, Your Honor.
Your witness, counsel.
Mr. Roberts, Patterson Baird recently lost the Republic Airlines account, didn't it?
Yes.
And that was one of your company's biggest clients, wasn't it?
Yes, it was.
In fact, that was the primary reason that Patterson Baird's revenues were down, wasn't it?
There are a number of reasons why our revenues were down.
But that was the main one, wasn't it?
I'm not sure about that. Someone in our finance group would know if that's true, but I really can't say.
You can't say.
No.
Do you recall having your deposition taken in this case, Mr. Roberts?
Yes.
And at that time, you were under oath, weren't you?
Yes.
Same oath you're under here today, right?
That's correct.
The one to tell the truth?
Yes.
Your Honor, permission to play excerpt number 10 from Mr. Roberts' deposition, lines 1 through 25.
Any objection?
Yes, Your Honor. The testimony is not impeaching and it contains speculation.
Overruled.
Why did you fire Ms. Stevens?
Unfortunately, I didn't have much choice. Our revenues were way down, and I was under strict orders from the powers that be to drastically cut costs in our group.
How so?
Well, it was pretty brutal. We had just lost the Republic Airlines account, which frankly was a total disaster. That account alone brought in $2 million in the third quarter, so that just killed us for the year.
Was that the main reason Patterson Baird's revenues were down?
I'm sure it was. I've always understood from the boys in finance that Republic Airlines brought in more revenue than our other top 10 clients combined. No other client was bringing in as much revenue, I can tell you that.
Mr. Roberts, you just finished telling this jury that you didn't fire my client because she was a woman, but because she was underperforming as an account manager, right?
Yes, that's correct.
Was my client responsible for the Republic Airlines account?
No, she wasn't.
Who was?
I was.
Were you fired for underperforming?
No, I wasn't.
Did your boss, John Patterson, ever put pressure on you to fire my client?
No.
He didn't.
No.
He didn't tell you you had to reduce headcount in your group by 10%.
Yes, he did.
And at that time, how many people were in your group?
10.
And how many of those were women?
Just the one.
Shannon Stevens?
Yes.
That's pretty easy math.
I see what you're implying, but John wasn't telling me to fire her. In fact, John didn't even tell me I had to reduce my headcount until after she was, well, let go.
Is that right?
Absolutely.
Absolutely. Your Honor, permission to play excerpt number 25 from Mr. Roberts' deposition, lines 5 through 10.
Any objection?
No, Your Honor.
So John Patterson told you you had to reduce headcount in your group by 10% in a conversation that you and he had in January.
Yes.
Mr. Roberts, you're aware that Ms. Stevens was fired in February, right?
Well, yes. But when I said that in my deposition, I was just guessing. I wasn't really sure when John and I had that conversation.
Mr. Roberts, were you given a copy of your deposition shortly after it was taken?
Yes.
And was that copy a word-for-word transcription of every question you were asked and every answer that you gave during your deposition?
Yes, but...
And weren't you given plenty of time to make any corrections that you deemed necessary in order to render that testimony accurate?
Yes,
And you, in fact, made some changes to some of your other answers, didn't you?
Yes, I did.
But you didn't change a word of that answer, did you?
No.
No further questions for this witness, Your Honor.
Patterson Baird & Company didn't fire Shannon Stevens because she is a woman, and they were well within their rights to terminate her employment. Nevertheless, the company was forced to pay a large sum to settle her claims because Pete Roberts and 2 other company employees were discredited at trial by testimony that they gave in their pre-trial depositions. Let's take a look at what Pete did wrong and how his mistakes and the company's misfortunes could have been avoided if he had followed just a few simple rules for testifying at a deposition. Rule number 1, always tell the truth. Although depositions often take place in a conference room or other informal setting, you should never forget that it is a formal proceeding under oath, and that your testimony at deposition carries with it all of the significance, as if you were sitting in a court of law before a judge and a jury. Of all the advice in this program, this is the most important and also the easiest to follow. You must always tell the truth in answering questions at your deposition. The law requires you to be truthful, and there could be significant penalties against both you and your company if you are shown to intentionally testify falsely. In addition, the other side's lawyer can use any inconsistency between your testimony and the other facts in the case to undermine your credibility before a judge or jury. As a result, you must never assume that it is a good idea to lie at your deposition. Pete Roberts told the truth at his deposition, but he still ran into trouble because he failed to follow the other rules for testifying in a deposition. Rule number 2, don't volunteer.
Mr. Roberts, what is your position at Patterson Baird & Company?
I am a vice president in the account management group. I've held that position for the past 3 years.
And what are your primary responsibilities?
Making sure all of our clients are happy and spending all of their ad dollars with us, and making sure none of them leave us for another agency. You know, the easy stuff. I also supervise the account managers who work in our group.
Was Shannon Stevens one of the account managers you supervised?
Yes, she was.
Why did you fire her?
Unfortunately, I didn't have much choice. Our revenues were way down, and I was under strict orders from the powers that be to drastically cut costs in our group.
How so?
Well, it was pretty brutal. We had just lost the Republic Airlines account, which frankly was a total disaster. That account alone had brought in $2 million in the third quarter, so that just killed us for the year.
Was that the main reason Patterson Baird's revenues were down?
I'm sure it was. I've always understood from the boys in finance that Republic Airlines brought in more revenue than our other top 10 clients combined. No other client was bringing in as much revenue, I can tell you that.
So what happened next?
Well, one day John Patterson came to me and said, we need to reduce the company's headcount, and you have got to cut your group by 10%.
Did he?
Yeah, he did. And so I took a look at each of the 10 managers in the group, who was handling which accounts, who was bringing in what revenue. That's how I made my decision that Shannon Stevens was the one who we had to let go.
And at that time, how many of those 10 managers were women?
Just the one.
Shannon Stevens?
Yes.
You mentioned Republic Airlines. Who handled that account?
That was one of my accounts. Tough luck, huh? In my defense, those guys were a handful, even as far as clients go. You're a lawyer, so you know how tough clients can be, right? I thought we were going to have to sue them when they refused to pay our last batch of invoices, but they came to their senses and we worked something out.
What did Pete do wrong in answering these questions at his deposition? Unfortunately, almost everything. Your job in your deposition is to take your time and to listen very carefully to each question and to answer only the question that you are asked. It's a common mistake to think that if you tell the other side's lawyer everything you know, he or she will see the light and perhaps drop the case or maybe just make the deposition a little shorter. You might do this in a business meeting or in a conversation, but you should not do it in a deposition. Why? Because information in a lawsuit is power. When you volunteer what you may think is harmless information, often the other side's lawyer will find a way to use that information against you and your company. Here, Pete volunteered a lot of information that he thought was harmless in response to questions that didn't ask for it. For example, Pete volunteered that his company's revenues were down because they lost the Republic Airlines account. Ms. Stevens' lawyers used that free information to ask Pete several more questions about the Republic Airlines account. Who was responsible for that account, whether or not it was a main source of the company's revenues. Her lawyer then used that free information against Pete and the company at trial to suggest that the decision to terminate her was discriminatory. At your deposition, listen very carefully to each question, and then stop and think about it, and then answer only that question. It's good practice to start using this technique from the very beginning of your deposition, when the other side's lawyer often will ask some basic background questions about you, your education, your employment history, your job duties. And if you start using that technique of listening, pausing, and limiting your answer just to the question, then you will be in good shape and practice to answer in the same fashion when you're being asked questions that are more substantive and material to the lawsuit. Let's see how a more careful and thoughtful witness would have handled the questions Pete Roberts was asked at his deposition.
Mr. Morgan, what is your position at Patterson, Baird & Company?
Vice President, Account Management.
What are your primary responsibilities?
I supervise the firm's account managers.
Was Shannon Stevens one of the account managers you supervised?
Yes.
Is Ms. Stevens still employed by Patterson Baird?
No.
Why not?
She was let go.
Why was she let go?
Patterson Baird's revenues were down substantially and we had to cut costs. Unfortunately, Ms. Stevens was one of several underperforming employees we had to let go.
When you say revenues were down, what do you mean by that?
Revenues were lower than they had been in the past.
And why was that?
There are many reasons for that.
What are they?
Well, one reason was our clients in general are spending less money on advertising than in the past.
Is that the only reason?
No.
What are the other reasons?
Another reason is that increased competition among agencies has lowered the commission we're able to charge our clients.
Okay, fine. You've testified that Patterson Baird needed to cut costs. What I'm asking you is, how did the company's need to cut back result in the decision to fire my client?
It was one of the reasons she was let go.
Was it the only reason?
No.
What were the other reasons?
She was underperforming.
Underperforming relative to what?
The other account managers.
Which ones?
All of them.
Dan Morgan is a careful and thoughtful witness. He's listening carefully to each question, and he's answering only that question. He's not having a conversation with the other side's lawyer, and he's not volunteering information. As a result, Dan is calm and in control of his deposition. No one, other than the lawyers who are involved in the lawsuit, will read your deposition from cover to cover. On the contrary, it's likely that the judge and the jury are only going to see excerpts from your deposition testimony that the other side's lawyers believe are helpful to their case.
For this reason, you should strive to avoid giving the other side's lawyers sound bites that they can use against you or the company at trial. One way to do this is to focus your testimony on who did what and who said what, and to avoid characterizing or commenting on those events. Depositions tend to last several hours, and in some cases several days. And it's a natural tendency to want to try and inject some humor or sarcasm to help lighten the mood or move things along or relieve some tension. You should resist that temptation.
Because those comments, when taken out of context, can be used to put you and the company in a bad light.
When Pete used the words brutal and disaster and the phrase, "and that just killed us for the year," he was serving up some terrific sound bites for Ms. Stevens' lawyer to use against him and the company at trial.
I'm not saying that at all.
As you know, Pete should not have been volunteering this information in the first place because he wasn't asked specific questions about Republic Airlines. But he compounded that mistake by describing those events in colorful, exaggerated, and quotable sound bites.
When testifying, you shouldn't comment or characterize the events that you're testifying about. Simply state what you did, what you said, and in doing so, you'll avoid giving the other side's lawyer ammunition to use against you at the time of trial.
It's also wise to avoid absolutes.
For example, even if you regularly read your emails, for you to testify that you always read your emails may be wrong, because there are instances when you may be out of the office or on vacation where you don't always read your emails. You're less likely to be wrong if you avoid words such as always or never in giving your deposition.
Rule number 3, don't speculate.
Some questions will ask you to speculate, which means that they're asking you to testify about what somebody else knew or did or said. But that is not your role in a deposition. If in a deposition you're asked to give testimony about what somebody else did or said or thought, unless you have direct personal knowledge of that information,
the truthful and correct answer to such questions is to say, "I don't know."
Did you, in fact, reduce headcount in your group by 10%?
Yes.
Did the rest of the company?
I don't know.
the same is true when you can't remember what you yourself did or said or thought at some time prior to your deposition. Then the truthful and honest answer is to say, "I don't recall." Because to say anything else would be speculating or guessing.
Did the conversation occur before or after you fired Shannon Stevens?
I don't recall.
Because depositions often take place months and sometimes even years after the events that you're being asked questions about, it's not surprising that you may not have perfect recollection, and there are events that you may be asked about that you don't recall with perfect clarity. In fact, there may be events that you don't recall at all, even though that you know you were involved in them. If that happens, and you truly don't recall, then the proper answer is to say, "I don't recall," or "I don't remember now."
If the other side's lawyer tries to embarrass or bully you because you said you don't recall, you need to stick to your guns if that's the honest answer, and you don't change that answer.
Unless there is something that happens in the deposition that does refresh your recollection.
It could be a document or some new information that comes up in the deposition, and you can always supplement your answer at that time.
As Pete Roberts learned the hard way, speculating at a deposition is dangerous and can and probably will be used against you and your company at trial.
Mr. Roberts, you're aware that Ms. Stevens was fired in February, right?
But when I said that in my deposition, I was just guessing. I wasn't really sure when John and I had that conversation.
Mr. Roberts, were you given a copy of your deposition shortly after it was taken?
Yes.
And weren't you given plenty of time to make any corrections that you deemed necessary in order to render that testimony accurate?
Yes,
But you didn't change a word of that answer, did you?
no.
No further questions for this witness, Your Honor.
Let's see how Pete got himself in trouble by speculating at his deposition.
Mr. Roberts, you testified earlier that John Patterson told you had to reduce headcount in your group by 10%, correct?
Yes, that's correct.
When did that conversation occur?
Wow, that's a good question. It's been a few years now, so I really don't remember when that was. I do remember that we lost the Republic Airlines account in November, and John and I had that conversation at some point after that. I was out of the office for most of December, and I remember that John and I were in my office when we spoke, so it probably was sometime in January, but I'm still not completely sure. You know, it's been a few years now, and I don't recall the date.
Mr. Roberts, is it your testimony that you can't remember when your boss came to you and told you had to fire one of only 10 people you supervised? You couldn't have had many of those conversations.
Well, I knew this was coming. Now he's making it look like I don't remember what was obviously an important conversation. Look, I'm 90% sure that John and I spoke in my office at some point in January, so I'm going to say January. I'm not saying that at all, and I remember the conversation clearly. I'm just not sure of the exact date. Having had a chance to think about it, I believe John and I had that conversation at some point in January.
So John Patterson told you you had to reduce headcount in your group by 10% in a conversation that you and he had in January?
Yes.
Thank you. Was Patterson Baird reducing headcount in every group by 10% or just in account management?
Let's see, John told me it was 10% in my group, but I'm not sure about the rest of the company. John was in the budget meetings, not me, so I can't be certain. But Steve Jenks in the creative group told me that he had to cut his group by 10%, and I know it was 10% in my group, so it probably was 10% across the board. My understanding is that the firm reduced headcount by 10% in all groups across the company, not just in account management.
Pete was speculating at his deposition when he testified that the conversation he had with John Patterson about reducing headcount in his group took place in January, when he really couldn't recall when that conversation occurred. In fact, his conversation with John took place in April, 2 months after Shannon Stevens was terminated on February 1st.
While Pete thought that his speculation was reasonable based on information he did have, it turned out that Pete was wrong.
And that innocent mistake was used to discredit him at trial.
A careful witness would have handled these questions very differently.
Mr. Morgan, you testified earlier that John Patterson told you to reduce headcount in your group by 10%, correct?
Yes.
When did that conversation occur?
I don't recall the date.
That's fine. Just give me your best recollection of when that conversation took place.
I recall the conversation took place several years ago.
Can you be any more specific?
Based solely on my memory as I sit here today, no, I can't.
Mr. Morgan, is it your testimony that you can't remember when your boss came to you and told you you had to fire one of only 10 employees that you supervised? You couldn't have had many of those conversations.
That is not my testimony.
What is your testimony?
I recall a conversation in which John Patterson told me I was to reduce headcount in my group by 10%. Now, as I sit here today, I can't recall exactly when that conversation took place, only that it occurred several years ago.
Did it occur before or after you fired Shannon Stevens?
I don't remember.
Was Patterson Baird reducing headcount by 10% in every group or just in account management?
I was told to reduce headcount in account management by 10%. I can't speak for the others in the company.
By declining to speculate about the timing of a conversation that he now does not recall, or by declining to testify about what others may have done or not done, Dan skillfully avoided the traps Pete Roberts fell into at his deposition.
It's important in your deposition to remember who you are and who you are not. By the same token, it's important to remember what your job duties and responsibilities are and what they are not. If you're asked to testify about events and circumstances and issues that are outside your scope of responsibility and of which you have no personal knowledge, then the appropriate answer is to say, I don't know. If you find yourself testifying in your deposition about what somebody else knew or did, you may very well be speculating.
It is particularly dangerous if you are being asked to testify about what the company, in a collective sense, knew or did.
Testify only about what you actually recall that you knew or did, and only if you're confident at the time of your deposition that you actually remember those thoughts or those events. And if you do that, you'll stay on solid ground.
Now that you've had a chance to see the first part of the deposition prep video, I want to focus in on a few things that I think make it particularly effective when we are talking about preparing senior executives. First, we mentioned before the need in many cases to scare them straight, because many senior executives are not inclined to take their depositions sufficiently seriously. The video does a good job in the opening trial scene of showing how innocent speculation at a deposition can be twisted, can be taken out of context, can be used to make you and your company look very bad. And that's not what you want to happen, particularly as a senior executive who will be seen as a key representative of your company. On the contrary, the senior executive must take the deposition seriously. They must want to prepare thoroughly, and then must want to execute their deposition according to plan and give a winning deposition. The deposition prep video can help you get your senior executive in that frame of mind when you simply tell them that these same things might not have the same impact as a dramatic video can. Second, the scene where the careless witness, who is a senior executive himself, is thinking to himself and trying to reason through something when they don't remember an exact date or an exact conversation, is very valuable for senior executives. Most senior executives will be tempted to do exactly that. Sit there and think about it and think about what they do remember and then try to put the thing they can't remember in context and come up with an answer because they don't want to say, I don't know or I can't remember. That's very dangerous in a deposition, as the deposition prep video illustrates. The third reason a deposition prep video is particularly useful with senior executives is because it's often a challenge to get the prep time with senior executives that you need because they're busy people and they don't want to deal with this litigation or this deposition. In some cases, you're fighting to get 3 or 4 hours of their time for in-person deposition prep, and you may have to do it over several days because they don't have that amount of time to devote to it in one sitting. Using a deposition prep video is a way that you can squeeze in a little extra prep time with them beyond what they will give you for in-person meetings. The way you would do that is after your first in-person meeting, you send them an email with the link and password and say, between our meeting today and our next meeting next week, please take 45 minutes whenever you have time. It could be in the morning, in the evening, or on the weekend if you need, and watch this program. Then, when they come back the second time, you can sit down with them and say, did you have any questions about what you saw? And you can use that as an opportunity to reinforce the advice that they saw in the video. Not only is it a way for you to squeeze an extra 45 minutes of prep time out of them when you're not with them, it also frees you up so you can focus your in-person prep time on the key facts and issues in the case. You can do more role-playing and practice questioning because you don't need to spend your time giving the basic advice that the deposition prep video covers really well. Recall what we also said about covering the basics without talking down to the witness. That's another benefit of the video doing that for you, so that your witness won't feel that you're talking down to him or her. Of course, you'll want to reinforce and ask if they have any questions about any of the 5 simple rules they saw in the video, but it's a real benefit to being able to offload the rote and basic advice to the deposition prep video. While these are some benefits of a deposition prep video that are unique to senior executives, the secret sauce of a deposition prep video is the same for all witnesses. It's being able to see, in addition to being told, how to give a good deposition. I've seen many witnesses who, after having seen the deposition prep video, go from hopelessly lost in terms of how to respond to questions in a deposition to really understanding how a deposition is supposed to work and doing a great job on deposition day. Indeed, the impetus for me to write the script for the Deposition Testimony 5 Simple Rules program was having had the experience many, many times of spending hours and sometimes many days with witnesses, preparing them for depositions, giving them all the advice that I'm sure every litigator who's watching this gives. Don't volunteer, don't speculate, just answer the question you're being asked, and then asking the witness, have you got it? And they say yes. And then 5 minutes into the deposition, the witness is volunteering, the witness is speculating, and the deposition is starting to go sideways. You're kicking yourself when you're not kicking the witness under the table and wondering, what could I have done better? I gave all the right advice and the witness just isn't following it. The critical thing I recognized is that until the witness can see it being done wrong and then see it being done right, they can't compare the two. They can't connect what you're telling them with how to actually behave because depositions are completely foreign, unlike anything they've ever experienced before, and they experience it for the first time in the deposition room. Litigators know, but witnesses do not, and no amount of telling them will make them understand what you mean when you say that a deposition is not a conversation and it's not a business meeting. Nobody would ever just answer a question as narrowly as possible and then sit there silently until the other person asks another question in any other context except in a deposition. It's such a foreign experience that a witness needs to see it done wrong and they need to see it done right before they can understand the difference. That is something that a deposition prep video can uniquely and effectively do for your clients. Our final topic for witnesses is practice. You should practice, by which I mean you should do some mock questioning in your prep sessions. One effective way to do this is to have a colleague come in and ask the questions of your witness so your witness can practice answer and you can practice objecting and otherwise defending your witness like you will do in the actual deposition. It is always good to do a little bit of mock deposition practice, and you shouldn't wait until the last minute to do this, although of course it's always going to depend on the schedule and how much time you have, but generally, starting early and spacing out the preparation is a good approach. That's because there may be things that you learn in a prep session that are very important that you didn't know, and they may require you to go out and talk to other people to sort them out. If the deposition is tomorrow, you may not have time to do all that, so being prepared and starting early is always a good idea. On a related point, while it's certainly possible to over-prep a witness to the extent that the witness gets really nervous about the deposition, it's more common to face the opposite problem. You can't prep the witness as much as he or she really needs because of time or other constraints. Still, you just have to use your judgment on this point, and I think you'll get a good sense after you've been doing this for a while how much a witness needs and how much is over-prepping. A few final points to spotlight for senior executives. One thing to focus on here in terms of the practice is to really challenge them. In this particular arena of litigation, you are the expert, unlike the business of the company, where the senior executive is the expert. This is your job. You're the expert, and this is what the company is paying you a lot of money to handle. And as a result, the senior executive should defer to you when it comes to preparing to testify in a deposition. In this regard, it's important that if they say something to you that doesn't seem right, you should feel free to challenge them. It's very likely that in their personal and business lives, senior executives are used to encountering a lot of yes men and women, people saying yes and yeah, of course, you're right, and I'll go do that right away. But litigation doesn't work that way. They're going to have the other side's lawyer challenging everything they say in the deposition or in motions for summary judgment or at the trial. And it's important for you to play that role. And don't be afraid to challenge something that a senior executive says if you think it's inconsistent with what you understand to be the truth or inconsistent with your theory of the case. You may end up needing to revise your theory, but you shouldn't be overly deferential to senior executives because you're doing them a disservice if you do that in a deposition prep scenario. On a related point, assuming that a senior executive gets it and doesn't need a lot of preparation or deposition practice merely because he or she has been deposed before is also very dangerous. While a witness who has been deposed 10 times probably knows the ropes pretty well, somebody who's been deposed just once before, and maybe that once before was in some family law matter where they were a trustee and it was a very different type of deposition, versus this case where there's maybe a critical witness or it's a critical issue for them or their company. You need to be sensitive to cases where a senior executive may think, oh yeah, I've been through that before, but that was in a small personal matter like a car accident or you name it, and therefore very different from what they're going to experience in a complex civil case. Lastly, practicing like you play is also good advice. When you're doing your mock questioning of your witness, perhaps by the third or fourth deposition in a case, if you, or even better, if your colleague is doing the mock questioning, is able to mimic the style of the lawyer that will be taking the witness's deposition, that can help a lot. Let's say the other side's lawyer tries the tactic of being everyone's best friend in the hope that that elicits more information. On the other hand, maybe he or she is a tough questioner who is going to go after the witness from the start. Or it's even possible that he or she is a very good lawyer and he or she does both, starting off being the witness's friend and turning aggressive once he or she has obtained the information they were seeking. Whatever tactics the other side's lawyer will be using, if you can try to mimic that as much as you can in your practice, your witness will benefit. If you don't know the other lawyer's style, then you should prepare your witness for both of these extremes. But I think as much realism as you can bring to your mock deposition, where you also are talking about the issues in your case and the documents in your case, is really very valuable. I think it's a great complement to the general civil litigation scenario that's presented in the deposition prep video, because you make it very personal to your witness by bringing it into the context of this case, by mimicking the lawyer who is going to be taking the deposition, and by talking about the particular documents and issues the witness is likely to be asked about. I think that combined approach is an extremely effective way to prepare both senior executives and anyone who's being deposed for their depositions. We've reached the end of today's program. I hope you enjoyed it and found it useful. Good luck in your next deposition, and thanks for joining me.